If you're a Criminal Defense Essentials annual pass holder, you know what the Golden Thread magazine is all about. If not, you'll be excited to hear that an annual subscription to our amazing criminal law magazine is available in electronic or printing form for as little as $20 for law students. In addition to case alerts, the magazine features engaging columns written by a variety of talented defense lawyers and professors. We have engaging writing from every perspective. Newer calls making their mark on the industry, and seasoned veterans sharing their expertise. Curious about important new cases and what's going on in the criminal law world more generally? Visit petersankoff.com to sign up.
Hey everyone, hello and welcome to another episode of the Criminal Defense Essentials podcast. We are doing something a little different today. First of all, we've managed to screen out all the hackers for those who are coming live. I got us into a webinar format, so it's impossible for us to be hacked the way we were last time, which is great. Pleased to see some people here, and I am pleased to be here today. We're doing something a little different. We are going to have, this is the first time I think I've had a guest on the Criminal Defense Essentials podcast, but I wanted to do so, and I wanted to try something a little different. I have a bunch of the usual stuff to talk about, including a wonderful decision from Quebec that you should be aware of. It's a very helpful decision on investigative detention and arrest, which is a useful area. But I wanted to welcome as my guest today, if she would put her camera on, I don't know if she can hear me, and her mic on. I have brought on board today my associate, Heather Gagnier, who is, there you go.
I can, I'm here.
I can barely hear you, of course. I don't know why. Speak again. It's a terrible microphone.
Can you hear me?
Yeah, I can hear you. It's just a terrible microphone. Okay. Fantastic. So I'm here with my my associate, Heather Gagne. You are the first guest on the Criminal Defense Essentials podcast. And like, you didn't have a choice. I ordered you to be here today.
That's correct. Yes. But I am also very excited to be here.
Good. So we had a bunch of stuff to, oh, hold on a second. I wanted to, it's asking for a passcode. Okay. Well, that's why I'm struggling, because I don't know how to do anything, right? That's the issue. The issue is, like, I have good intentions going on, but I think that the profile that is pinned does not have the passcode in it. See? So as a result, people can't get in. I don't do this very well. I try, but all the technology sort of gets on my, yes, you need a password. So I'm like, why is nobody here? And the answer is, I didn't put the password in. The people who did get here must have put the password in. So you know what it is, but I can probably find it out with a little bit of work. Here we go. I know all of this is very exciting, but I just forget all this stuff. Oh, wait a minute. Copy invitation. There we go. I am fixing everything. I'm putting the passcode in. It's weird that you have to link in even with a passcode, but I guess you do. Okay, this is all very exciting. But Heather, it was not as exciting as our journey to the courts today, was it?
Yeah, I think today's experience was probably the highlight of my legal career so far.
So I don't venture out to the courts very often, like, for good reason. But every time I do venture there, I'm just amazed at how things run. So what I mean by that is, Heather and I both attended today for the purpose of figuring out, watching our colleague Shireen, who's doing a prelim, except of course she's not actually doing a prelim, because what I've found is, like, it seems to me, Heather, that like 1/3 of things actually scheduled to happen at a courthouse actually happen. And it usually takes several hours just to launch those things in motion. Is that your experience as well?
Yes, I think a third might be a bit generous, actually, especially when it comes to trials. But
I just don't get it. I know people who attend court regularly are sort of used to it, and they sort of show up, and yeah, it might run, it might not run. Yeah, the witness might show up, they might not show up, and yeah, we'll figure it out as we go. I just get there and I'm like, I see all these lawyers jammed into various courtrooms and sometimes negotiating and sometimes not negotiating, and sometimes the trial goes and sometimes it doesn't. I just look at it and I'm just amazed how much waste there is. I mean, I was there at 9. Sorry, I got there a little after 9, so 9:15, and I was just sitting down in the cafeteria, so I wasn't actually wasting any time. I was on my computer, but like we got out of there at 11:15, correct? And like nothing had been accomplished. A judge was sick, so like they didn't have enough courtrooms for everybody. And like, although both witnesses and all the people necessary to run the trial the preliminary inquiry just didn't go ahead. You know what I mean?
yeah.
And everybody
Yeah.
seems fine with that. Like, it's just, I understand this was a judge sick as opposed to witness not showing up or courtroom not available. But I just, again, I'm sort of like, my mind is blown with the way everybody seems okay with the whole thing. And, you know, so much of it just depends on the attitude of the participants that are there that day. Like, does the Crown want to go ahead? I don't know. It just seems to me, from what I've experienced in my time, there just doesn't seem enough incentive for everybody to avoid doing this. And as a result, it just keeps going along this way.
Yeah, I think there's a lot of, I mean, it's always been this way, so no one's really maybe bothered to try to figure out a better way. And it is a little bit astounding that in 2022 we can't do better.
Yeah, like I think remote appearances had a lot of advantages, and I know the courts are still doing remote appearances in some places for certain types of things like docket. I mean, don't get me started on docket. I've already dealt with that. I would abolish 99% of docket like tomorrow. I would appoint case managers and just say, okay, well, parties figure it out, and these are the dates we're going to go. I would get rid of all in court or virtual appearances that didn't have a contested issue. I would only bring in the court where there was something contested. And my general view is that if the parties are complacent in getting things going, that's the problem of the parties. Like, I just think the court should be less concerned about that, and perhaps worry a little bit less about that. So that's the way it is. Hold on one sec. Let's see. Yeah. I think this person is not really trying to ask me a question. I think we have a hacker. That's just my guess, but I'm not going to allow the hacker to talk, so don't worry. Oh, it's glitched. Okay, well, maybe it's not
a hacker.
But we'll see. It's still open season. Oh, cool. Okay, great. Fantastic. Welcome. Okay, I have brought Heather in not to talk about the vagaries of the court system, but actually to talk about some exciting news, exciting from everybody's perspective, but exciting especially from Heather's perspective. Heather is a lawyer who works in my office, and she has a great love for appeal work. Is that correct?
Yes, definitely.
So tell us about your love of appeal work, Heather.
Where to start? Well, I think I started in law school. I did a lot of mooting in law school. As you know, Peter was my moot coach. And I didn't expect to really be good at it or to love it like I did. But the first time I ever did it, it was the most amazing feeling. And it's just incredible to be able to get up and make your own arguments and engage with the panel in a really like intellectual and deep way. And I think that's what draws me to appellate work. Especially appellate work at the highest level, which I'm sure you're going to come to, but it's just so exciting, the idea of kind of making law for the country, as it were.
Yeah, absolutely. That's the fun part of it for me as well. And that's my specialty is appellate work. And Heather's been brought in to assist me with that. And this year, she's now appeared on 2 appeals. All right. It was the second one.
Yep.
Yeah, and the first one we lost, and that's the end of that. It was a sentence appeal. I think we did a good fight, but we lost together. And then this was the second appeal. So why don't you tell our audience a little bit about the appeal? You can read the appeal judgment now. It is online. It's called R versus BEM 2022 ABCA 207. Heather, why don't you introduce a little bit about the case?
Sure. So there were a few issues we argued in this case. One of the main issues was an issue of myths and stereotypes and concern about the jury charge effectively telling the jury to ignore what, in our view, was a key part of the defense case. So to give you a little bit of background, this is a historic sex assault allegation. The complainant then, for years after the alleged abuse stopped, continued to associate with our client and in fact left her own son in his care overnight, sometimes multiple times. And so at trial, defense counsel argued that that's something that should be considered in terms of assessing her credibility. But of course, the trial judge got overenthusiastic in my view on charging the jury about myths and stereotypes and effectively came out and told the jury to ignore that evidence because there's no one way a victim of sexual assault will act. So that was one of the main issues we argued. Interestingly, though, we don't have an as-of-right appeal on that issue. So the issue that we did get leave to appeal to the Supreme Court of Canada on is actually an issue of the Crown's closing submissions in this case to the jury. So in this case, a big issue was the fact that the complainant's memory had been changing over time and more details had been added. Defense argued that that should really impact her credibility. And in trying to argue against that line of reasoning, the Crown in this case basically gave his own kind of personal anecdote about, well, look, I had this memory when I was a kid, this happened, and I remembered it this one way, but then, you know, years later, my dad told me, well, actually, those details that I had remembered weren't quite accurate. And so, you know, that just shows memory changes over time. This is the way it works. You know, and my example shows that you can rely on the complainant's evidence and you can believe her. And so we argued that that's improper. And really, that's the Crown giving evidence. And obviously, that's something that the Crown is not entitled to do. The trial judge never instructs to ignore it. And so that was the issue that I was arguing at the Court of Appeal, and that's the issue that we got a dissent from. So that's the one that's going to be going up to the Supreme Court.
Now, keep in mind, everybody, as we go forward, I have a very strict policy of, you've probably noticed this before, like if you follow me on Twitter, I have a very strict policy. I don't argue my own cases on Twitter or on the podcast. So Heather and I are simply reporting the case. We're not suggesting the decision of the Court of Appeal is right, wrong. We're obviously arguing against the majority decision, but we're not going to weigh in as to why it was right or wrong. We'll leave those arguments for the court. I'm more interested in having Heather here to talk about, you know, the more exciting part of it, about going to the Supreme Court. I should add, though, if anybody goes to read the decision, we are hoping to seek leave on the myths and stereotypes point. We think it's really important. It's one of the issues that has caused a lot of, if you've listened to me at all, when we talked about sexual assault cases, I have a concern about the way myths and stereotypes are being used in jury instruction and also by trial judges. Maybe used is the wrong way. The concern about myths and stereotypes has sort of overtaken, in my opinion, the way in which evidence can be used. But we're going to leave that to the actual appeal. And obviously, like, we're very excited to be able to argue on this. It's an interesting issue. It'll be fun to get up and, you know, look at the 2 decisions and put them before the court, and hopefully, obviously, for our client, obtain a new trial in this case. So more importantly, let's talk about the decision. Now, Heather, I gotta say, I think like we have to put it before the listeners that like when you got the decision, you somehow thought we had won the case. Is that fair? Sorry to
Yeah, I
embarrass you, but
scrolled
that's literally what happened. I was like, what do you mean we won? Heather was the only
I
person in
scrolled
the
down
country
to
who
I
thought
would
we won.
allow the appeal,
You
and
went
I
to the
got
end, right? Rookie mistake. Because
yeah.
the
So
Justice Veldhuis's decision, she wrote the main decision, but her decision comes second, and it just says at the end, I would allow the appeal, and Heather was overjoyed.
I always scroll down to the end first. I got to read the end first to see. So yeah, rookie mistake. Won't
Yeah.
make it again.
But anyway, that was fun. How did you feel when you realized, well, we hadn't won, but we were obviously obtaining an as of right to the Supreme Court?
Yeah, I mean, it's the best loss I've ever had in my career, that's for sure. It's incredibly exciting. I can't wait to go. Yeah, very, very excited.
Yeah, it's going to be great fun. I mean, it's of course, like, I think at this point, projecting forward where COVID is concerned is probably never a good idea. I'm never about to say, well, we're going in person, but obviously as things stand right now, it looks like we will get to go in person. So I'd imagine that's especially exciting.
It is, yeah. I've been to the Supreme Court once before, not as a lawyer, just on a tour. And I remember thinking, like, I want to come back here as a lawyer someday, and I didn't think it would happen this quick. So, yeah, very, very excited.
Yeah, it is cool. I've had to do my last two appearances remotely, and it's not quite the same thing. I mean, I do like the ability to have a coffee just slightly out of the way of the screen, which is a handy thing, right? But it didn't have. I mean, I was there most recently in the JJ appeal, which we're still waiting on, and like, JJ should have been like one of the greatest days of my career. I was only there for an intervener, but there were just so many good advocates there. And normally you'd be able to meet and really like, get into it and just focus on what's happening. And instead it was, I was focused, but it's just not the same, obviously. So getting to be there in person is, of course, wonderful. Also nerve-wracking, though. You'll see that.
Yes, yeah. Probably going to be pretty nervous, I think. But
yeah, when the judges make their way out. So yeah, it's pretty exciting. I'm absolutely thrilled that we've been able to get that. I have to be honest, like, I don't know why, but for some reason I've had this idea that I would get an as of right in like a bunch of appeals, like, because I've run a few at the Alberta Court of Appeal, and I've had judges where I thought one judge was really interested, and like over and over, I've always thought, we're going to get one, and I never have. This is the first as of right appeal I've had. And what's interesting in those cases, because you were in one of them, although of course in Martineau it was a sentence appeal, so we wouldn't have gotten an as of right anyway, right? You only get it on convictions. And there was a dissenting judgment or a concurring judgment in Martineau. But like in Martineau, just to give you an example, I was pretty sure that like the judges were split, right? And they were, but in the end, they just split on one of the legal points, and they all agreed we should lose. So, but I've had that happen before. And the funny thing was, I wasn't really preparing for it in this case. I actually, for some reason, thought we would win or lose outright on the main point. I hadn't really suspected that the secondary point, as good as it is, was really what captured their imagination. And I think in part that was because we got no indication from the bench of that during the hearing. Most of the questions were related to the first point of argument.
Yeah, I think that's definitely fair. It was a little bit of a surprise to me as well. So.
But a good surprise, a pleasant surprise. So off we go,
yeah.
Onto the Supreme Court. Okay, more broadly, Heather, what is it like for you? What is it like for you to be a young criminal defense lawyer? You didn't article in criminal defense. You didn't train in that area. How do you find the adjustment to criminal defense practice?
Well, it's definitely a learning curve, that's for sure. Still learning something new every day. I'm sure I will be for years. But I mean, one of the reasons I switched is I wanted to do cases that, number one, I thought, were really important and had a big impact on people's lives. And then also cases that are just legally very interesting and make my brain work. And so both of those things I've definitely gotten in spades, having switched doing criminal appellate work, especially. So it's incredibly rewarding work. It's very heavy sometimes, for sure. I've experienced that this week a little bit with some clients where I've, things I never had to deal with when I was a civil litigator, right? Like just, it kind of impresses on you, the enormity of what we do and how it really impacts people's lives. But I'm very happy to be doing it. It's definitely very rewarding work.
Yeah, no doubt. And you do feel that impact. I mean, our job isn't to judge our clients, obviously, as defense lawyers. And as appellate lawyers, especially, like, you keep in mind that in most cases, except the rare cases where I'm dealing with a Crown appeal, like, our client's been found guilty, right? So it's definitely not our job to judge them. Like, they've been judged already, right? Like, the verdict is in, and our focus is largely on errors that that we believe cause some flaw to emerge, usually in the trial process, sometimes in the reasons for judgment. But I agree with you that I can only imagine what it's like for the trial lawyers, because we do some trials. Heather has some trial clients. I have rare trial clients, but most of our work's at the appellate level. And like you, I'm there in some sense when the client is being sentenced. Usually, we do have clients that are incarcerated by the time we get them. But we have many other clients where we're there on the day they're going into incarceration. And one of the reasons for that is, especially in Alberta, it's not my favorite part of the system. The Alberta rules are set up in such a way that it's really quite hard to get bail pending appeal for a client within a reasonable period of time after they go in. And by reasonable period of time, I mean a day or two. It is very common for clients to go into custody unless the Crown consents. And I'll leave that topic for a moment, because the Crown is not that inclined to consent as often as they might have in the past. Certainly they haven't been on my files, but that might just be me. But as a result, like, leaving aside the Crown's discretion and whether or not they wish to consent, what concerns me even more is just that the rules are set up in such a way where, like, your client is going to do a month or 3 weeks at least in custody every time, even if you have a really good bail application. And the reason for that is just that it's just so hard to schedule the bails, because, like, the sentencing has to take place before you can launch a bail application, because you can't launch one. There is nothing to appeal from. Sorry, I take that back. The sentencing doesn't have to take place. I take that back. But the sentencing does have to be scheduled. And then by the time you try and schedule it, like, the rules require 10 days notice to the Crown in order to launch the bail application. 10 days might not seem like much, but, like, you have to be able to schedule it in such a way that there's actually a hearing date. So it ends up usually, in my experience, being 2 weeks minimum. We've got one where we did it in 2 weeks, which is kind of amazing. I don't even know how we did that. In fact, that's our client right now, right? 2 weeks, but usually you're looking at 3 weeks. And, it's tough to tell the client, you got to go in for 3 weeks. Like, we think you're going to come out, but they do 3 weeks of time. And to me, I learned that in Ontario, the timing for bail applications, the notice is 3 days. So, like, it's meant to be really short. And that does concern me a great deal. I don't even know how to raise that with the various courts, but I do think that the 10-day period, while sensible for certain types of applications, is really troublesome for bail.
Yeah, I agree. And I think what's interesting about that issue and in this case is it really brings home part of what I like about the appellate work, obviously, is that it is sort of divorced from the facts in a sense. Like, you're really arguing the law and the legal points, and I do really like that. But it's a good reminder of how it's a real person at the end of the day in this case, and these things, like, our justice system really impacts on these people, and it's not abstract in that sense. It really relates to somebody's life, right? And so that's been
well,
really
we
good
see
reminder
that
for
when
me,
they
I think,
speak
this
with
week.
us and express their concerns.
for sure. Yeah, definitely.
Yeah. And what's interesting about that is like, again, I just want to be clear so that people don't think that we're just, defense softies, which we kind of are, right? Because we kind of are, because like that's the role we take on, right? We're there to advocate for our clients. But I do want to say that like it's not unheard of to win cases on appeal. That's the issue that I have, right? I understand the idea of bail, and I understand, okay, and everybody's like, okay, well, it's not that big a deal. You've been convicted of this crime. You go spend 2 to 3 weeks in jail. But I guess my point is like, we win appeals quite a bit, right? And then like that conviction goes away. And I think about, for example, I'll give an example. Last year, we had a client, he was convicted. He was supposed to go in right after, right? We launched the appeal and he was supposed to go in. And really the only reason he didn't go in was because of COVID. It was a while back, right? And he doesn't go in because of COVID. Everything's sort of delayed. We're able at that point, because of COVID, to negotiate a bail consent with the Crown, right? Fine. Then we file our appeal materials. The Crown actually consents. I mean, it was a rare occasion of the Crown conceding that the appeal had merit and went back for a new trial. And the client was acquitted at the new trial. And like, again, the default position, we were lucky that our client really didn't spend time in custody, but the default position is effectively that the client will spend time in custody. And, 2 weeks might not sound like a lot. Oh, 2 weeks of custody, but man, to a lot of these clients who've never been convicted, like I wouldn't want to spend 2 weeks in prison.
No, it's life-changing for sure. And I think what's frustrating a little bit is, coming from the civil law world, if you don't consent to something that you ultimately lose, there are consequences, and in criminal there are not, right? And so that can be frustrating too, that the default positions just get taken, and at the end of the day, someone spends a couple of weeks in jail, and it's but it's a big impact on their life, as you raised. So it is very frustrating.
Yeah, that is a real problem.
This turned into a bail rant, but
yeah, it does get into that. But yeah, I tend to agree with that. And we did the research too. There is really no way to deal with that. But anyway, I don't want to get into too much of a bail rant. I want to shift gears because I do like to keep our podcast short and snappy. Last week's was 30 minutes, and I thought that was a nice bite-sized digestible. So I want to talk about a case that's coming up. Heather doesn't know what I'm about to speak about, but I'm sure her ears will perk up because it's on a topic she has worked on recently for another file. This is one of my favorites, of course, because I'm bringing in a case from Quebec, which is my home province. And anybody who's followed my seminars and Criminal Defense Essential series knows that I'm really concerned. I'm always concerned by how little lawyers use Quebec cases in their arguments, which for defense lawyers is really silly because the Quebec Court of Appeal, it's arguably the most open-minded court in the country. I mean, not on everything, but generally speaking, it's very common to find very helpful decisions from Quebec. And this is one of them. It's a case called Leventis, 2022 Quebec Court of Appeal 291. And it's really about reasonable grounds to arrest. But what I think is most interesting about this case is that it really takes a hard line on the distinction, which comes up over and over again, between reasonable grounds to suspect that can justify a detention and reasonable grounds to arrest, which justifies a search. And those are two really different things. And this case does a great job. And there's some great language in there from the court about how this works. So Leventis, the beauty of it is the facts are super simple. There's a 911 call that the police receive with an anonymous tip. And there's a man selling drugs at a restaurant, and his name is Costa. That's all you need to know. Okay. The anonymous tip does give a pretty good description of the accused. So the police get there, they see someone who looks like the accused, looks like the description. He starts walking away when they get there. So they yell out Costa, and he stops and turns. Like, to me, nobody even contested a trial. Like, they have reasonable grounds to detain. There's just no doubt in my mind, right? They've got, you're an expert on this subject, Heather, given our recent research for another case. Like, you agree, that sounds like reasonable suspicion, right? I mean, they have the tip, they have the description, he's linked to drugs, he's walking away, he answers the name. Like, seems fair, right?
Yeah. Yeah.
But the question is always, what does that detention justify? So here's where it gets interesting. They do put him under investigative detention, and to their credit, because this doesn't always happen, they caution him and they tell him why they're detaining him, right? No problem there. They get ID from him and start running a check. So far, I'm on board. Everybody's on board. The court, the defense lawyer are all like perfectly proper. They've got enough to ask for that. They've got enough to do some checks. Here's where it gets a little interesting. So during the 10 minutes while they're trying to get more detail on the 911 info, and they're also running his ID, the officer observes that Costa is nervous, that his phone is going off constantly, and that he's constantly adjusting his belt. So the officer decides that those provide reasonable grounds that he is likely carrying drugs, and therefore at that point they arrest him, which of course allows them to do the search around the waistband where, you know, the officer's hunch is damn good. That's why we're here. He's got a whack of drugs around his belt. So that's where we get this case and what it actually says. What I like about this case, it's the decision of Justice Vauclair from the Quebec Court of Appeal, is that it really spells out what is the problem with this search. And the court has little difficulty both finding a breach of Section 9, a breach of Section 8, and excluding all the evidence. So it's a pretty good defense-based case. And here's the line I like from Justice Vauclair. The law requires greater rigor from the police and greater vigilance on the part of the courts when called upon to rule on the legality of the arrest, because reasonable suspicion is not reasonable grounds. There's nothing groundbreaking there, right? But it's a really good articulation of the fact that reasonable suspicion does not guarantee the right to search. It sometimes guarantees the right to search for safety purposes in a limited way, but you should never conflate the idea that, well, we can detain and therefore we can then search. The reality is that all they had here was an assertion by an anonymous person. They knew nothing about the motivation. That does not provide reasonable grounds to believe. And quite frankly, the officers knew that, because they didn't arrest on site. They knew they didn't have it. And then Justice Vauclair looks at all the evidence. What's interesting about this part is the officer, of course, asserts that my experience showed me that those types of things mean he's carrying drugs. And this relates to yet another case we recently worked on, Heather, because what I like the Court of Appeal said in this case is that the officer's subjective experience didn't add anything, because the officer was unable to provide any objective criteria as to why these things justify arrest. So as a result, they're just hunch and instinct, right? Grabbing at the belt. How often does that result in drugs? Like, what are the criteria you actually used? And the court is going to be more demanding for reasonable grounds to believe, as opposed to reasonable grounds to suspect. And that's what I think is the lovely aspect of this decision. The justice said that the officer's assertion of experience, which is what he said, I have a lot of experience, was not very useful to objectify what was at its core a highly subjective interpretation. You'd love to have that case for one of the things we're working on, right? It's a good little case.
Yeah.
No doubt.
Absolutely. Yeah.
No doubt. So my feeling is this. Number one, I want to remind everybody that reasonable grounds to suspect is not reasonable and probable grounds to arrest. I'd also remind defense lawyers out there that whenever you hear an officer talking about experience, you want to remind them and you want to ask a lot of questions about the reason for that experience. Quite frankly, I'd be like asking them about their statistical likelihood of finding certain things. I'd be trying to expose the fact that their hunches may or may not pay off. And that as a result, like, they can't be used as a form of reasonable and probable grounds to believe. This case is also great because, like, when you're trying to explain to law students the difficulty between reasonable grounds to suspect, which I think was easily met here. I really do. I think the anonymous tip, someone's selling drugs, they show up, there's drugs. But like, clearly that's not enough to get to the next threshold. And then when you have, like, he's nervous, his phone is beeping a lot, Well, let me tell you that, like, when my daughter gets caught when she's not supposed to be on the phone, like, she would satisfy the nervous, I don't know if she grabs her belt, but her phone is going off constantly. So I don't know about that one. Finally, I want to remind everybody of this because, and this line will be familiar to Heather. What were the police supposed to do in this situation? Well, you know the answer to that, Heather. What were the police supposed to do in this situation if they couldn't find more?
Get a warrant?
How would they get a warrant based on that?
I don't know.
Yeah.
I don't think they would. I don't know.
I don't know why, because you wrote the actual line in one of our factums. It seems to me that if police can't elevate their reasonable and probable grounds, they only have one option in this case.
Let them go.
Let them go. And that's the part they forget, right? It just doesn't work any other way. You can't just arrest because you've got a suspicion. That's just not the way it works. And I think the case is pretty clear in asserting that, right? If you can't get over the articulable cause or the reasonable suspicion, the fact that his phone's beeping and he's nervous, well, it might give you a little more suspicion, but it's not enough. Stopping and detaining people is an extraordinary power. And you cannot jump to the arrest no matter how good your hunch is. Sounds about right?
Sounds right
I know
to
you
me,
think
yep.
Right, because we're arguing in several cases. Well, that is a great case for you. I remind you that the citation for that is Leventis 2022 Quebec Court of Appeal 291. All right, Heather, that was an exciting, as always, I open the floor to questions if there are any. We haven't gotten any questions. And again, our audiences tend to be small because I continue to mess up how this all works. Like I am somehow mystified by all the technology of what's going on. It's very depressing, but that's what happens when you're as old as I am. All right, everybody, thanks so much for coming out to the Criminal Defense Essential podcast. Thank you to Heather for joining me. I hope you enjoyed it. I spoke most of the time, as always, but I hope you liked it.
I did, yes.
And good luck to you at the Supreme Court, because when I say that, I also mean good luck to me, right? That's the way it works, because we're going together. Yeah. All right, everybody. Thanks so much for turning out. Have a great day.